Thank you. Friends, good evening here. I just wanted to correctly introduce myself. I'm Teesta Setalvad, and I'm from Citizens for Justice and Peace, CJP, not CPJ, Citizens for Justice and Peace. Thank you very, very much for having me here. And the discussion today, is my voice coming clearly, sir?
Yes.
Yeah.
Yes.
So today I've been asked to speak of the entire experience and the importance of the law that we tried to get enacted post Gujarat 2002, the Prevention of Communal and Targeted Violence, Access to Justice and Reparation Bill 2011, commonly referred to as the Communal and Targeted Violence Bill of 2011. Friends, I need to, first of all, so I just would like to begin by saying that we are meeting in 2022, 11 years after a aborted attempt to get that bill tabled. We are meeting at a time in India when the calls for genocide of the minorities have become blatant and open. We have, excuse me, is there some problem in the connection? I can't see anything on the screen.
No, you are audible, you are visible. You are audible and you are visible.
Okay, because the screen is showing something black. It's very strange. Yeah, okay.
No,
so I'm just saying that we are meeting at a time when the calls for the genocide of the minorities have reached an all-time high. We saw December 2021 when in the quote-unquote holy city of Haridwar, we saw genocidal calls being made at a Dharm Sansad. We saw another Dharm Sansad in Allahabad just 1 week back making another genocidal call against the country's Muslims. And we saw over 330 attacks against the Christian community last year all over India. So we are meeting at a time in the country where you have communal forces in power, and therefore the time and the need to, of course, debate such a law is very, very critical. But I think it's also important to go into the background of why such a law was thought to be needed and why did one feel that it was necessary at the time. So first of all, I'd like to offer this idea that every democracy is premised on the assumption that while the majority can take care of itself, minorities need special protection. The Communal and Targeted Violence Bill seeks to protect religious and linguistic minorities and scheduled castes and scheduled tribes from targeted violence, including organized and communal violence. Now, I want to stress here that when we worked on the draft, and this work took right from 2004 to 2011, the first draft that was brought out by the Home Ministry of the UPA-1 government was very unsatisfactory. Therefore, the NAC then constituted a rigorous committee and we worked on the second draft, and that is why we are discussing the 2011 draft. The tragedy is that this bill was never tabled by the Home Ministry or the Law Ministry in Parliament, and it has therefore been aborted, an aborted attempt even before it began. We found there were huge hurdles. The police bureaucracy and the administration just did not want a law which guaranteed some degree of accountability from the police force and the administration. I'd like to start off by saying that why the need for such a law? The need arose out of decades-long experience dealing with targeted and communal violence, including the findings of Judicial Commission reports right from the 1960s, 1970s, 1980s, whether it was the Jabalpur 1961 violence, the Ranchi 1967 Justice Raghuveer Dayal Commission, Ahmedabad 1969 Justice Jagmohan Reddy Commission, Bhiwandi, Jalgaon and Mahad 1979, the Madan Commission of Inquiry, Tellicherry 1971 Justice Joseph Vidyathil Commission of Inquiry, Hashimpura and Meerut 1987, Bhagalpur 1989, not to mention Shri Krishna Commission report into Bombay 92-93, Gujarat, the Concerned Citizens Tribunal headed by Justice Krishna and Justice Suresh. All these very thorough, judicially driven commissions of inquiry, official and non-official, they highlighted two aspects dealing with targeted and communal violence. One was that silent yet strident mobilization by right-wing supremacist groups through hate speech and hate writing against religious, linguistic, and ethnic minorities before the violence breaks out. And though these have always amounted to violations under the IPC, they have gone unchecked and unpunished, creating a climate that is fertile ground for the actual breakout of violence. We are seeing what's happening with the Dharm Sansads. We are seeing what is happening on social media. We are seeing the deleterious impact of Facebook and Twitter, where they don't take down the perpetrators of hate speech, like we saw in the Delhi 2020 pogrom, which took place in the national capital, to break the back of the anti-CA, anti-NPR protests. And we're also seeing that something I had documented in the 1990s first, after my city, Bombay, burned. And then, of course, we saw it in Gujarat in a full-blown way. And 2022 will be 20 years after the Gujarat genocidal pogrom, that the institutionalized communal bias in the Indian police and administration has only increased and become more entrenched, because we've seen the sort of infiltration of a certain supremacist anti-constitutional ideology into the wings of governance. And that is why we need to address these lacunae, these imbalances, through a special legislation like the Prevention of Communal and Targeted Violence Bill. Now, hate speech and hate writing play a very unique and negative role in building up a climate of complicity among the majority. For months and days before the first stone is cast, repeated demonization of an already marginalized section takes place. So then finally, when the violence actually breaks out, a kind of a social compliance and a social consent for that violence has been created. This particularly deleterious characteristic of hate speech is very important for social activists to understand, for lawyers to understand, for political players to understand. Because we have to understand the real distinction between free speech and hate speech. Article 19 certainly gives us the right for free speech, free expression, free association. But Article 14 and 21 also gives us the right to live a life with dignity and with equal protection before the law. So if one person's free speech given from a position of social, economic, and political power harms the targeted sections' right to life with dignity, and right to equal protection before the law, then there has to be a curbing of that kind of free speech, because it can also instigate violence. Now, it's very important, the whole process that came about when we attempted this draft, which is a very rigorous process, when we looked at the findings of judicial commissions, the inability of mass targeted violence to be prosecuted. In fact, my organization has managed a unique feat of getting about 172 powerful perpetrators of the Gujarat 2002 pogrom punished. 124 were to life imprisonment. On principle, we did not ask for death penalty. But it's very, very rare to get any convictions in mass and targeted crimes. And that is the anomaly that this law tried to address. It tried to set a chain of command responsibility, that so that the perpetrators are not simply those who are on the ground conducting the violence, but also those in the police and administration whose constitutional and legal and administrative duty it is to implement the law, protect lives, and protect property, which they do not do. So therefore, this very unique provision of tracing a chain of command responsibility and making civil servants, SP, DM, civilly responsible for this abdication is also a key part of this law. if you see the kind of nature of communal and targeted violence in our country from the decades of the 1960s, 1970s, 1980s, 1990s, and now, of course, we are in 2022, we see a very, very the change of the character of this violence. That from riots like Jabalpur and Ranchi, which arose out of a certain issue where the right-wing, the supremacist right-wing played a part, and a biased police force acted in a partisan way. They progressively moved in the late 1980s to pogroms, out-and-out pogroms, where the actual contestation was between a very partisan police and administration and a beleaguered minority. And in the 2000s, particularly after Gujarat, then we saw Muzaffarnagar, now we see Delhi 2020, we've seen them almost like full-blown pogroms. A study conducted by reputed institutes in 2019 that interviewed 19,000 police officers across the country found that 70% of them believe that Muslims are more violent and 30% believe that Dalits are more prone to violence. So we are seeing this phenomenon of a kind of a prejudicial partisan attitude within institutions of governance. And therefore, a law of this kind, a proposed law of this kind, is meant to mitigate that. Now, it's very, very interesting that when we went about the task of trying to draft the various provisions of the bill, the very first thing that we dealt with, and this is something important to understand because there were a lot of misunderstandings about this bill, is that minority, quote unquote, is not or should not be a rigidly frozen concept based on religion alone. That was our considered opinion when we attempted a definition. The reality on the ground is otherwise. As our sordid experience of the attacks on Kashmiri Pandits in the Kashmir Valley, or the violence unleashed on North Indians, Biharis in Mumbai, and Maharashtra or Thamizh in Karnataka has shown, with the migration of populations and altering demographies, democracies need to develop sound measures for the protection of all their people. Jurisprudence through justice delivery and reparation through compensation packages must reflect this ever-changing reality. There is a simple way. For instance, this is before the abrogation of the state of Jammu and Kashmir in 2019, when the state was won. We argued in 2011 that in fact, that even to get such a bill passed in Jammu and Kashmir was possible because all you needed to get was a consent of the Jammu and Kashmir Assembly under their constitution. A law to protect the minorities draws its source from already existing powers. Now, a major point of contention at the time in 2011 was a concern of the states. And I remember that time, Tamil Nadu Chief Minister Jayalalitha, then Chief Minister West Bengal, Mamta Banerjee, and some others had expressed concern about the fact that something called a national authority that was constituted in this proposed legislation, drawing on Article 355 of the Constitution, might mean that the federalism principle might be impinged on, and the states would therefore be at the mercy of a vicarious center. That concern needs to be dealt with. If we are talking today of a reverse situation, where in Delhi and in the capital you actually have majoritarian supremacist forces governing, then state governments, particularly like the one in Tamil Nadu and Bengal and in other states, need to consider the enactment of a state version of this law, which addresses the issue of command responsibility, fluid definitions of minority, district to district, linguistic, religious, ethnic, all of these, and thinks of compensation calculated in an objective way so that reparation and not compensation is assured to any victim of targeted violence. We need to also guarantee that there should be objective criteria to decide at which point this kind of the provision of this law is to be held. Because as all of you know on this forum and other forums, for instance, the Atrocities Act, before that, the Civil Rights Act of 1955, then the amended Atrocities Act, 1989 Act, which was amended in 2015, we have seen how that despite the existence of such a law, we see the fact that very often the police authorities and the administration simply don't invoke those sections of the law. We saw that in Khailanji massacre in 2006 in my state of Maharashtra, and in many states where Dalits are victims of mass crimes. So the very important aspect of an implementation and the enactment of such a proposed law has to be that the police and administration is made to acknowledge the structural and societal bias that exists, where a large section of our people are more vulnerable and are everyday vulnerable to targeted violence. This is a very important criterion. There were many concerns expressed at the time when we were drafting this law, and I will address some of those concerns also. But before coming to the concerns, I would mention that the experience in the drafting of this bill, we addressed the question of witness protection, fair investigation, the rights of victims during trial, and the thorough scheme of compensation and reparation, which were welcomed even by the critics of the bill. Now, our particular experience in cases like the Best Bakery case and in so many other cases that coming out of the Gujarat 2004 program showed us that the integrity of the investigation is really maintained by the state police, and not even by the CBI, which people have called a cage parrot in the past. So what do we do to ensure that our investigating authorities have maintained objective criteria uninfluenced by the political executive? This is a very important question, which state governments also need to examine, and the central government also needs to examine. Because the integrity of the investigation actually finally assures prosecution. Whether it is the Prevention of Communal and Targeted Violence Bill or the Atrocities Act, it will eventually depend on the police force that is meant to implement it, on the investigating agency. So unless we are able to ensure the integrity of investigation, which means we have to enact police reform, which means we have to enact a complaint standards authority for the police, which means that the political executive needs to allow that the state police, which is under the law and order situation, is answerable to the assembly, and answerable to the assembly, not answerable to the political party in power at the time. We also have to ensure that the state police and the CBI and the NIA, which are federal agencies, all these three wings of investigation are not malfeasantly influenced by supremacist ideologies like the Rashtriya Swayamsevak Sangh, VHP, and Bajrang Dal represent. We have seen in the functioning sometimes of these agencies and the manner in which investigations are conducted that we do not find constitutional values of equality and fair play being the criterion. So it's very important that we ensure an independence of investigation. We also need to ensure the independence of prosecution. Now, I don't know about Tamil Nadu, but I know Maharashtra and at least 8-9 other states in the country. There's a constant battle between civil rights movements, citizens groups, minority rights groups, and the government to try and ensure that the role of the public prosecutor is also given dignity and integrity. And that can also be done by a certain degree of autonomy, good compensation and payment, because invariably defense counsels are paid much more than what the state pays the public prosecutor. And does the public prosecutor enjoy very close relationships with the police structures and investigating agencies, or is there a distance maintained? These are very crucial questions. Our experience in Gujarat showed us, and the Supreme Court has actually commented on this in 2 major judgments, how in many cases the public prosecutors function like defense counsel. So it's very important in that independence of investigation, independence of prosecution, witness protection. That's the other thing. Witness protection is not something that we pay attention to. I know our entire adversarial structure, which is the structure where the eyewitness has to come, and many of these mass crimes and targeted crimes only get prosecuted when when the witness stands in the box, the witness who's a witness to these mass crimes. And in our structures, we do not provide for empathetic and viable witness protection. Without witness protection, you are not going to get the prosecution that we want for the culture of impunity to be reduced. Including this, it was following the findings in the Best Bakery case that in 2009, Parliament enacted an amendment to Article 24A(2) of the CRPC and Article 272, which for the first time allowed in law the victim and the complainant's family to be part of the prosecution and not dependent wholly on the state prosecutor. Earlier, it was left to the discretion of judges whether to allow this or not. But following this amendment in 2009, now there's a statutory right that the victim has to represent his or her, the family of the victim has to represent his or her own case in court. This has been some movement forward. Coming back again to the whole issue of the opposition to the Prevention of Communal Violence Bill. The major opponent, of course, was the then in opposition, now ruling BJP, Bharatiya Janata Party, and it's very, very clear why they were in opposition, because they simply wanted to treat communal violence as a law and order problem. Not only that, they wanted to not just treat it as a law and order problem. I remember Arun Jaitley's public article at that time against the proposed proposed law. But their assumption is also that only a certain community is more prone to violence than another, and that Hindus only act in reaction. So these are the extremely sensitive structural issues that are facing Indian democracy today. And it is something, I'm aware of the crisis brewing in Tamil Nadu over the last few weeks. And I'm aware also that whether it's the BHP, Bajrang Dal and the RSS, that a certain extremely communalized reality has begun to emerge in the state. I remember, as I'm sure many of my senior colleagues on this panel do, that in the early 1980s, it was Tamil Nadu again, when the Hindu Meenakshipuram conversion issue was falsely blown up by the Hindu Munani, and you suddenly saw a surge of a kind of very supremacist upper caste Hindu sentiment emerge in the state of Tamil Nadu. So we need to go back and revisit some of these moments when a leap has been made by majoritarian supremacism, and understand why they are being made. And obviously the whole issue of trying to target the Christian minority just now in the state of Tamil Nadu over Lavanya's suicide is a major issue. We also need to ask ourselves that when Christian institutions, when Muslim institutions are functioning as per democracy and the law and the rights that minorities enjoy, why is this constant demonizing taking place? We also need to ask sometimes questions like, should not the whole issue of caste and caste differences within minorities also be factored in to some of the minority institutions so that they follow constitutional principles and values? Having said that democracies based as they are on electoral and representative politics reflect and must reflect the voice of different sections. But we must also realize that India today is being called an electoral autocracy, only a partly free country. And therefore, our democracy today privileges the majority. This is for a variety of reasons. Otherwise, too, it might have happened. But today it's happening because we have in positions of constitutional governance those individuals and that party in power, which by its very ideological moorings is anti-constitutional. They are sworn to actually overthrowing Dr. Babasaheb Ambedkar's constitution, which is not just Dr. Babasaheb Ambedkar's constitution, but was written with much vigor after the Constituent Assembly sat over an 18-19 month period and deliberated on every act, including the preamble. When you have this kind of ideology trying to overturn the delicate balance that must take place between the balance of power, which certainly lies with the majority in one sense in a democracy, but which must always give space and protection to the minority voice, even if it's a single voice, that balance is being completely lost today. So therefore, we must constantly ask ourselves about the past decades of Indian governance, even before the supremacists actually gained power in a full-blown way in 2014. They had power before that from 1999 to 2004 as well. That's when Gujarat 2002 happened. But even before that period, the ideology of the supremacists was already infiltrating the positions of governance, the structures of governance. So we need to examine all of this candidly. We need to recall moments like the Nellie massacre, February 18, 1983 in Assam. What are the factors behind the Nellie massacre? When overnight 2,500 plus laboring agriculturalists, Bengali-speaking Muslims were slaughtered. And then over the period of the next week or 10 days, even another few thousand were slaughtered. What happened in 1984 under a Congress regime, when after the assassination of Mrs. Gandhi, over the next 3 or 4 days, 3,000 Sikhs were massacred in the state's capital and a few thousand more all over the country. These are moments when you see majoritarianism rearing its head, even when the party in power is not sworn to anti-constitutional or majoritarian values. Therefore, we need to develop a subtle and a thorough challenge to this majoritarianism that has crept into Indian democracy. We cannot deny that 1983 happened in Delhi, Assam. We can't deny 1984 happened in the country's capital. We can't deny Gujarat happened. We can't deny Muzaffarnagar happened. We can't deny 1969 Ahmedabad happened. Meerut Malyana 87 happened. Bhagalpur 89 happened. These are moments of huge, violent, targeted upheaval where the very basis of constitutional governance was struck. Fortunately, we've had police officers. We've had police officers who've spoken up against this. We've had 9 police commission reports which have asked for police reform, which have said that we must have representation of the minorities within the police force. We must have state complaint structures where citizens can complain about the police. We must have the police force which is not reporting to the executive and power in the state. But unfortunately, our political parties show reluctance to actually enact these police reforms, administrative reforms that are required to have the integrity of investigation, integrity of prosecution, witness protection, etc. Will Tamil Nadu take the brave step of trying to debate such a law and enact it? It is to be hoped that, like it has pioneered so many things in the arena of social justice, welfare schemes, etc., it will also have the boldness to do this. But to be able to do this, it will also have to have a lot of debate, dialogue, and ensure that what is being done is in the interests of deepening democracy and furthering democracy. Finally, I'd like to add that in addition to the Prevention of Communal and Targeted Violence bill that was proposed by us in 2011, side by side, the Sachar Committee report and the Amitabh Kundu report of 2014, which is a follow-up to Sachar, also suggested an anti-discrimination law. Now, I think the two things need to be looked at together, because anti-discrimination law was also something that Dr. Babasaheb Ambedkar had proposed. He had in fact said when he talked in his seminal work, State and Minorities, that every department of the government should have a discrimination officer, anti-discrimination officer, to whom people can complain if jobs are not given, if schemes are not given, if things are not implemented for every minuscule minority, religious, linguistic, and ethnic. And therefore, that will enrich Indian democracy in a way that nothing else will. So the Amitabh Kundu report of 2014 has suggested that an anti-discrimination law or an equal opportunity law, both are two sides of the same coin, be enacted, so that if there's a section of people, Indians, who feel that the institutionalized bias against them is not allowing them entry into the police force or the administration or as teachers or as doctors in public institutions or private institutions, they can actually litigate and try and get redressal. So these are some of the issues I wanted to flag today. Thank you very, very much for the opportunity. It's about 25 minutes since I've spoken. I think I'll stop now and basically end by saying that there could be no better time than 2022 to revisit the urgent need for the Prevention of Communal and Targeted Violence, Justice and Reparation Bill of 2011, and the Equal Opportunity Commission law and the anti-discrimination law has been suggested in the decades between 2006, 7 and 2014. I don't have much hope today from this government at the center, but if the state governments, particularly the government of Tamil Nadu, shows leadership in this regard, there were some of us who've had experience in this entire, not just battling communal violence, but also drafting this law, would be very, very happy to offer our expertise and help. Thank you very much.